Welcome and good evening. This is the October 8th, 2025 meeting of the Evanston Land Use Commission. In a bit of a departure from our regular procedure, we do not have any public hearings scheduled for this evening, so I'll dispense with my usual opening statement and ask that we, I guess, call the roll.
Commissioner Miranchev?
Here.
Commissioner Magnum?
Here.
Commissioner Harris-Furry?
Here.
Commissioner Pucktell?
Here.
Chair Lindwall?
Okay, I'm here, and with 5 members present, we actually have a quorum this evening, and present from city staff are Liz Williams, planning manager, and, Sarah, you are not Brian Johnson, Sarah Flax, community development director. Okay, thank you. So tonight we have 2 items on our agenda, both of which are discussions items, and I believe with discussion items, we don't vote on anything. Is that correct? That's correct. Okay, the first item is Land Use Commission Rules and Procedures Update. And I presume, Liz, are you going to kind of discuss that?
Yeah, I can kind of walk the commission through this agenda item. So essentially, the Land Use Commission has been operating as a combined commission now for a few years. And we thought it would be worthwhile to have a discussion with all of you about your rules and procedures and things that you've encountered and staff has encountered as we conduct under one unified group. This used to be the Plan Commission and the Zoning Board of Appeals. It was combined in, I believe it was 2021, if I remember correctly. Might have been 2022.
It's a little later than that, I think, 22?
22, yeah. It's been about 3 years. So at this point, staff has prepared just very high-level agenda with a few items that we think are important to get feedback from the commission. And you're welcome to add any additional items that from your perspective as you're going through your rules and procedures that you think need to be addressed and called out. The goal here would be to bring back for your review kind of a marked up version of the rules and procedures based on this discussion and kind of staff's perspective on the rules and commission for November 12th, the November 12th meeting. And then you'll have the opportunity to further wordsmith. So this evening, we don't necessarily have to pin down exact language of what you'd like to see. It's more of a high-level conversation. And then we'll bring back a track change version of your rules and procedures for further review on November 12th. So in the memo that was in your packet, we identified several items. The first of which was clarifying virtual participation. We recently started offering Zoom participation, which is pretty much the city's practice for most boards, commissions, and committees. And it's also allowed by the Open Meeting Act in terms of commissioners being able to participate under certain conditions. And so we would propose that your rules and procedures incorporate some language around how you would like to conduct your meetings as it relates to allowing members of the public and or commissioners to participate virtually. So welcome any feedback on this first item, and then we can kind of move through these individually if that works for you, Chair.
That would be fine.
Okay.
Okay, anybody have any thoughts? We've really only done one meeting with virtual participation.
Are you saying that our current rules just aren't clear enough to permit it?
They don't necessarily contemplate virtual participation, and so I think what staff is kind of looking for is a lot of boards and commissions do allow members of the public to provide public comment, and in this case, it would be public comment or testimony as it relates to public hearings. So we would just want to clarify that that's an option for community members as they're interacting with the commission. And then we would likely incorporate some language from the Open Meetings Act in terms of what are some of the allowed circumstances by which commissioners can participate virtually. So again, it's just bringing in alignment with other boards and commissions here at the city.
Are you sure you want to manage all of that virtual participation?
It is obviously a consideration, but I think from an equity standpoint, fairness standpoint, staff believes that it's just good to provide as much opportunity for public feedback as part of your proceedings, especially just given the nature of the business that comes before the commission. But I do appreciate it. It is an additional administrative item, but we typically have more than one staff at these meetings anyway, and we can juggle if it's something that the commission also thinks is important.
Yeah, I think it worked fine.
Yeah, I think it's important to have virtual opportunities for members of the public, especially those who work and may not be able to get here by 7 o'clock. They may be working in Chicago or just outside of Evanston. Is it possible to remove the certain conditions for commissioners to participate virtually? I think now it's currently if you have a child care issue, and I'm not sure what the other reason is.
Illness or work.
Yeah, we would need to make sure that commissioner participation is in alignment with the Open Meetings Act. We can certainly check with legal, but my understanding is that there's only certain circumstances that have been afforded to virtual participation, and it also would require the commission to take a vote to recognize whoever's participating virtually. In addition, typically you need to have a full quorum in person in order for there to be virtual participation as well. So we would want to clarify all of those provisions in the rules.
Yeah, I believe it is state statute, so I don't know that we have that flexibility. Okay. Don't know if anybody else has anything on that item. I think that one's fine.
Okay.
So moving on to the continuance request.
Yeah,
which
this one is-
obviously is the more, well, I don't know if it's contentious, but it is unclear.
Yeah, it's definitely unclear at this point, and I think the rules would benefit from some clarification. Right now, per my understanding of the city code, the continuances can be requested by any taxpayer of record that lives within the noticing radius for a case. And so that varies in terms of 500 feet from the site to 1,000 feet, depending on what type of application you're reviewing. In your rules, it does also allow for continuance requests to be made by anyone with interest in real property within that same noticing radius, which would include business tenants that don't maybe own a business. It would also include renters that live within the radius. They hold a lease, but they don't necessarily own a property. And I think from staff's perspective, again, we think it's important to offer fair representation when reviewing cases and requesting continuances. So our recommendation would be to ensure that any taxpayer of record shall be granted a continuance request. Your rules currently give you discretion on whether or not you want to grant continuances to folks that don't own property within that noticing radius, and also stipulate that those individuals have to provide a reason for why they're requesting the continuance. It's basically automatic if you're a property owner. It's the commission's discretion if you're not a property owner. That's kind of how the current practice has been handled, and our understanding of the rules that you have currently. And we just want to make sure that that's how you'd like to continue conducting your business as a commission. So,
What are some reasons why someone would have a justifiable reason for wanting a continuance?
typically, it's to provide additional evidence to the record from their perspective, based on what the applicant has supplied. They can bring expert testimony to a follow-up commission meeting.
But they feel like the notice period is insufficient?
I think that's part of it. They didn't have enough time to align those items in time for the hearing. You know, our packets typically come out the Friday before your meetings on Wednesday. So there is the potential that certain expert tests or those that might testify wouldn't be available in that short time frame, or they might just not have the ability to prepare those remarks in writing. So again, my understanding is you have to grant continuances. It's non-discretionary if it's a taxpayer by city code. And I think there was an attempt to change that previously, but that did not make it through city council. And I think that also there may be some provisions in state law that afford that opportunity as well for continuance requests.
I think the other reason that continuances have typically been needed is until you've heard the applicant make their presentation and present their case, you don't know necessarily what it is you disagree with. Or, a lot of times we'll get material and it won't necessarily have all of the detail that even we need up in the, up here. So I think that it is, we've had it happen a couple of times lately. We certainly had it with the Ryan Field case, but that was a very major issue. I mean, there was a point in time, probably 10 or 15 years ago at this point, where, residents routinely asked for a continuance just kind of because. So I think that kind of the rules we have about tenants and presumably businesses, kind of that's probably where that came from. But frankly, if it's automatic for a taxpayer, I don't have any particular reason with just saying it's automatic for anybody. And I don't know that, and there was, the whole business about having a reason because it helped to focus the subsequent meeting. Because, what was happening is, the continuance would be requested, and then you'd go through the same hearing the next meeting. And I think that was kind of the intent was to try to avoid that. And I think that at least with the most recent one, I think that, we did get new testimony, and I think it worked fairly well. But, it seems to me that rather than have to go through this whole, thing, if you're a tenant or a business owner, you have to have a reason. It has, you have to, have us approve it. And I'm not sure what basis we would reject that request for a continuance. It seems like, treating, they are kind of technically different classes of interest within the area, but that's, I'd just as soon say, one continuance is automatic. And now, I guess the other question is, we do want it in writing, or do we not care if it's in writing? That's another,
Yeah, I think the current city code does not require taxpayers to provide a written reason. It's just an automatic continuance request.
so they don't
if
need to
it's-
have it in
yeah,
writing even.
Correct.
So we could have a rule, that our rule could basically say, if you request a continuance when you get up to speak the first time, that's sufficient? Is that how you're interpreting that?
I think for taxpayer of record, correct. You could add a provision in your rules that would require, those that aren't taxpayers to provide a written reason. But if I understand what you were saying previously, your feedback would be to just allow anyone within the noticing radius, whether or not they own or rent, or are a business owner, they can just request a continuance and they do not need to provide a specific reason. But again, it's up to you. I think you just don't have the discretion to require a taxpayer to provide a reason, if that makes sense.
Right, and when it doesn't have to be in writing either.
Correct.
I mean, it seems to me that we ought to be treating pretty much all entities within the notice, area the same, but, I will defer to other thoughts.
I agree. I think they should be treated the same. I mean, people rent for a reason, people buy for a reason. They all should have the opportunity to, let their voice be heard. So an oral continuances should be allowed.
I agree with that too, just a second. But what prevents, let's call it, avalanche of continuances? I mean, continuous over a continuous over a continuous. Is there a rule for that?
Sure. Typically what happens in terms of your public hearing procedures, which again is something we want to validate with you this evening, is we will hear testimony from anyone who signs up at the first public hearing. And then you as a commission will close public comment after the last person has provided their feedback, and then you'll call for continuance requests. In the city code, it does specify that there's one continuance request granted, shall be granted. And so your rules could reflect that same provision, so that there's not kind of an open-ended kind of requests for continuances. It's always at the commission's discretion to reopen public testimony, which could then afford folks that weren't at the first hearing to provide comment testimony and then request their first continuance. But again, that's at your discretion as to whether or not you would want to do that for any given case.
Can we,
Thanks.
during the request for continuance, it seems to me, ought to be made by the speaker during, their initial comment, rather than, I'm not sure if it makes a lot of sense to, let everyone at the first hearing speak, and then at the end say, hey, does anybody want a continuance? I would rather, if they know that that's an option, they can make that request after, while they're doing their initial comments, would be my preference.
So, yeah, I agree with what's been said about, of course, providing no differentiation between different types of classes of people to be able to have this right. I am very concerned about people using it as a delay tactic when they really, as just a way to obstruct proceedings. So I would like the new rules to reflect that the continuance request should be made as early as possible. And in fact, I would actually not, I don't want to spend 2 hours listening to people give public comment and then grant a continuance, and then we have another meeting where people get back for public comment again. We've listened another 2 hours where people just repeat the exact same thing, and we've wasted our time. I would want the continuance, if it's going to happen, to be open and fair, but then available right away. And then if we do it fine. And then we stop and we can continue later, so we're not wasting our time. And then also to just clarify, so if, I guess 2 things. One is, yes, I do think it'd be important for someone who makes their continuance request to state a reason, so that they are just on the record for something, because that can then be used, because they don't provide a reason, then they can come up with some other reason to possibly justify another continuance. And if they can state what their initial reason was at the onset, then we know how to make sure we're granting the continuance in a proper way to satisfy whatever the reason is. And then also just to clarify, if when a case gets continued, that essentially satisfies everybody's request or initial right to have a continuance. Is that correct?
That's correct. And that's part of the reason why I think the continuance requests come after public comment and testimony has been provided, because then it gives the commission the opportunity to close that portion of the hearing. And you're procedurally moving to the next request, which is continuances. So you're not then at the following hearing, hearing from everybody that wants to speak on a case. You're only hearing from those that had formally requested a continuance at the first hearing. And if your rules specify there's only one opportunity for a continuance request to be requested by an individual, then you are basically, in essence, eliminating what you're talking about. The only time that potentially someone else that wasn't at that first hearing could request a continuance is if the commission as a whole votes to reopen the public comment and testimony portion of the hearing. Does that make, I'm trying to like,
Yeah,
it
that's
is
a little better.
currently it is currently a linear process, I think, intentionally, because it affords anyone that shows up for the first meeting on a topic to share their feedback about that, and then that portion of the proceeding closes, and then you call on anyone who's in the room to come to the mic and say, I want to request a continuance, and then you've got a list of 5, 10, who knows how many people who have requested that continuance. If I'm understanding everyone's position this evening, everybody would get that opportunity that comes forward during that portion of the hearing to request a continuance. And at the next hearing, you're hearing from only those individuals and their experts, if that.
Okay.
And we cannot require a reason from everyone. Is that right?
That's correct, yes.
However, I think it would be nice to be able to at least encourage or suggest, because, you know, one of the issues when you're providing a continuance, particularly where the individual is bringing experts, is it's kind of nice for the applicant to know what the basis of the continuance request is, or something, you know. I suppose that can just be part of my little spiel, but
Yeah, and we can also just in the rules say, it's recommended that you provide,
or it's encouraged.
Yeah, it's encouraged that you provide a reason.
In order to
Yeah.
facilitate our deliberations and
Right.
the applicant.
And can it, a reason that pertains to our standards, right? Can we add that?
Yes,
language?
I mean, you can, we'll work on some language around that. I don't want to be too prescriptive just because of, I think, the way the city code reads right now, the property owners don't have to provide a reason at all. So it is really discretionary if someone who's requesting a continuance wants to. But we can definitely encourage it in the rules.
Yeah, and I think that's, again, just kind of somewhere in the rules, just the acknowledgement that our decision, our recommendation is based on the standards contained in the zoning ordinance.
Great. Any other feedback on that item? Otherwise, I think we've got enough direction to at least draft some initial language for your review at the next meeting.
Okay.
The next one is around establishing deadlines for acceptance of written evidence and petitions for distribution to the commission. Our recommendation is that the rules provide adequate time for staff to compile and forward those written comments received after a meeting packet is posted on the commission's website for review. And we also think right now the language around procedures for submission of petitions, which typically only apply right now to, I believe, map amendment cases that come before you. We want to provide a little bit more clarity on petitions. You know, historically, we've gotten varying kind of styles, I'll say, of petitions.
Well, and it's also, we don't like this project versus we
Right.
have, you know, because for the map amendment, the petitions have actual, some legal
Yes.
weight.
correct,
And I
yeah.
don't know that any other petition carries any legal weight, does it?
It's just, you know, I think an indication to the commission whether or not there's opposition or support for a particular item. And, you know, absolutely, we're not going to regulate the use of like online platforms for petitions, people wanting to organize petitions. I think we want to clarify in the language around what is required for a petition that has legal standing as part of a map amendment case. And then also providing enough time, because those typically go to the clerk's office. They have to verify whether or not the individuals listed in that petition are taxpayers and within the noticing radius. So it does take a little bit of staff time. And right now, I think the rules would say, you know, you could provide that up to 5 p.m. before the meeting. And that's absolutely not enough time for staff to validate whether or not it's a valid petition.
It's also, you know, by the time it comes to us, you know, getting our last comments at 5 or 6 the day of the meeting is challenging to read the comments.
Yeah, and that's the other piece of this is that's the first kind of sub-bullet under this item is when we receive written comments. Right now, I think we give folks up to 5 p.m. before the meeting, and it does not give you very much time to read those, reflect upon them. So I think our request would be that they come in a little bit sooner if they're going to be transmitted to the commission in advance of the
Say
meeting.
at least by noon of that day. But, you know, others may have thought, especially those of you who work, whether or not that's
24 hours. Minimum.
Yeah, I would say probably 24 hours.
so, you know, 5 p.m. on the day before the meeting.
Okay, that's great.
I think would be good. And then I think the other kind of point on some of the, well, I guess that I'll get into the people who want to speak or submit comments or, you know, especially when we were talking about, you know, under the old continuance request, you know, when people don't get the, you know, they get the packet at Friday night like all of us do, and it may take time. I think there was a rule that said you had to request a speaking thing by, you know, noon on Monday or something silly. And I don't think that's fair to the public, you know, we worked it out where I think, what was it, again, that same 24-hour request, because it takes people a little bit of time, or, you know, you want them to read the packet, and if they have objections, I think maybe that same 24-hour before me, would that give staff enough time to deal with that?
So I think you are moving on to the next item, which is the update requirements for speakers on behalf of a group,
Yes.
an individual or institution, and their ability to provide testimony. Right now, it actually, I believe, is 5 business days before the hearing to request. And to your point, Chair, there's not 5 business days once the packet comes out for someone to know whether or not they want to organize a group and present on behalf of those individuals. So I think we would recommend that time be reduced. And if I heard you, probably 24 hours would be adequate.
Yeah, or well, 48 hours doesn't give you much time, that doesn't give a group very much time to organize either, so.
Right.
I think, again, most of our hearings, we tend to be fairly flexible in letting, members of the public speak. For example, we don't always limit testimony to people who live within the official notice area, which I presume technically we could, but that hasn't been our practice. So,
Wait, do our rules currently acknowledge this practice of someone speaking on behalf of a group? And if so, can you just help me understand, like high level, the concept? Because it seems, just from my experience, it seems like it's pretty haphazard in terms of a group of people deciding that they want to hire an attorney or someone to speak on their behalf because they feel that will help their position. But I'm not clear how like formal of a practice that is.
Let me find that really quick in your rules. Says it's under. Gotta love a control find. So right now, it basically establishes that at the chair's discretion, 10 minutes may be granted to designated speakers of community groups. Those requests need to be in writing no later than 5 business days before the scheduled date at which the case is going to be heard. It should include or shall include the name of the community group and a list of individuals or institutions being represented. It provides kind of general examples of what those groups may include and clarifies that it's not considered a petition, and you reserve the right to clarify public comment, cross-examination of any member of the public that speaks in a hearing. So that's kind of how the current rules speak to groups.
Okay, thanks. So we're talking about changing that 5 days to 1 day and adding something about the rest of the group members waiving the right to speak?
That is correct, if the commission would like that to be the case. I mean, we are asking for them to provide a list of who they're representing, and they're getting up to 10 minutes to speak on behalf of those individuals. So it would be, again, how you would choose to proceed.
Because right now, the representative of the group gets their 10 minutes, and then everybody in the group also speaks their mind. Mm-hmm. So, and presumably, they don't want to give up that right. So,
and one way to kind of work through that would be not to include every member of that group on that list that you're sending in.
Right.
And they then wouldn't be waiving their right to that representative speaker.
Right.
So, it's not saying that everybody that may be affiliated with that group is automatically not allowed to provide their own individual testimony, because let's face it, not everybody in a group always aligns on their perspective. So I think it would be the group's leader that would need to identify who they're speaking on behalf of.
Yeah, and, clearly we had that situation recently. I think that there's another section, the section 6, section 5, which also talks about the testimony being limited to 3 minutes per person, which I think is a reasonable amount. It makes for some long evenings for us sometimes, but I think it's really important that anyone who wishes to, speak on behalf, at any of these public hearings gets 3 minutes, because they're not likely to get that much time at city council when the matter usually gets to them. So I think that's important. But again, that then goes on to say, when allocating speaking time, the chair may give additional speaking time to those who have a legal interest within the notice. So I think we've got to look at both of these things to kind of figure that out, because I think that my preference would be to just give everybody 3 minutes. Fortunately, especially as evenings tend to wear on, not everybody takes the full 3 minutes. So, Commissioner Mangum.
Is it possible, so 3 minutes in general, and then maybe if the speaker list exceeds like a certain number, then make it 2 minutes per person? Is that possible?
Yeah.
I think we can.
Like maybe, I don't know what our typical numbers are, but is it, if it's more than 25 people, or is it more than 50 people? Then
Isn't
it
it just
goes,
at the speaker's discretion?
yes, I guess so.
Yeah.
Or, yeah.
Yeah, I think it's generally, and frankly, I can, talk about, if the speakers spoke before, if others have testified to your point, you don't need to take the time. So, but I think that, I think 3 minutes is kind of a general rule of thumb in the state. I'm not sure if legal has a.
Yeah, we can certainly work with legal to know if there's anything in statute that requires a certain time frame. I'm not aware of that, but I know that there's some
I know
best
that-
practices out
that-
there.
Yeah, but I think that like 1 minute is not considered, it's probably not considered adequate. And usually we don't have controversial issues that where we have to limit. Where we've got dozens of speakers.
Yeah. So I'd be willing to even increase the 10-minute time to something greater if the group identified like a minimum number of people that had to required to form that group, and then those people really could not speak. Like increase it to 15 minutes, and you have to have a minimum of 5 people, right? Because then you're like, you're literally you're grouping those people's time and allotting it to that designated person.
Yeah, I'd like to try to keep our rules as simple as we can so that they're understandable. And I think that, 10 minutes has generally been worked okay. And just as chair, if somebody's going over the 10 minutes, but they're, or even like an applicant, you don't want in the olden days, applicants would bring their team of experts and they'd spend 3 hours making their presentation. And, and I think that trying to have the presentations be limited to like 20 minutes, although clearly we've had instances again, where the applicant has exceeded that time. But, our mission here really is to hear from the public and make an informed decision. So I think we're kind of the sacrificial lambs when it comes to letting the public speak, but I think it's important.
So can I just quickly summarize what I think I heard from the commission, just to make sure? Sounds like you're okay with reducing the amount of time necessary to request folks to speak on behalf of a group. You want to maintain that they provide a list of who that group is representing. You will then not allow members of that group their individual time to provide additional comment. It's representing, that speaker is representing those individuals on that list. Potentially, the more individuals that are on the list, the more time they may be afforded to speak on behalf of that group.
Sure.
And I think that's all I heard related to groups. But I also heard that the chair has the discretion to potentially allow people listed in that group additional time to provide testimony. Is that accurate, Chair? Or no?
I'd rather not do
Okay.
that, but I think that it is reasonable for, so generally, I think we can say 10 minutes for a group, but the chair has discretion to allocate additional
Time dependent
time,
upon how
depending on
many
the
people
si-
are
yeah, Depending on
represented.
the size of the group.
Perfect. Okay. Thank you
I
for
think
that.
and
Okay. That's crystal clear. Thank you.
that work with everyone?
Okay. We'll work on language on that, and then you can review it and
Okay.
beat it up at your next meeting. The next one, again, this one would reduce the deadline for applicants to request additional presentation time. Similar to groups, our rules currently say they have 5 business days before the hearing to request more than 20 minutes for their presentation. Our recommendation would just be the same practice across all requests for additional time. So it sounds like we're landing on about 24 hours is what you're recommending.
Well, I think applicants are a little bit different, because applicants will have submitted all their material, and I would think, that I don't know if 5 business days is necessary, but you kind of, for managing it, wouldn't you like to know kind of how long their presentation is?
I don't think we need more than 24 hours
Okay.
to
All
manage
right.
that, but
All right.
again,
That's
it's up to you.
That's fine. But I'd encourage them as staff to keep
Yeah,
it
we
to
always
20.
encourage more time as staff, but at a drop dead deadline is always appreciated as well, just so we can set
Right.
expectations.
And then you guys have got, kind of standard requirements for when they give you their PowerPoint and all of that, I presume.
Yeah, usually it's by noon the day of the meeting. All right, I'm gonna quickly scroll.
Now, I do have a question on the procedures for the hearing the cases. We have a section 3 where staff may provide a brief presentation summarizing the staff report, which I think is helpful, although lately we haven't, that's not something we've, typically, staff has not typically done that. So I don't know that you need to change the rule, but it would be nice if we kind of heard from staff, especially, kind of why they're supporting or not supporting, or maybe why the certain conditions were suggested. That's just kind of my thought. I don't know if there's certain kinds of, other than reading the case into the record, that would be that other commissioners would find helpful. And we do have the memo, and that's always good.
I'm confused. What are you suggesting?
On section 3.
Yeah. Or she's
When-
referring
I'm in the
to.
I'm in
Yep.
the order of the
Page.
procedures of the public hearing.
It's not
on
something in
12.
the memo. It's a different
separate-
topic.
I'm just looking at the rules.
What she's referencing is procedures for hearing a
Open
case.
public
Yeah.
hearing, and then section 3, typically, the staff reads the case into the record. But, our rules sort of say staff, suggest that staff might make a brief presentation. Just an overview of maybe some of the concerns staff had in terms of why certain conditions were suggested. Just, I would
It's
find.
been
but-
my general practice to always have a staff presentation when it comes to cases before the Land Use Commission. When I started here, this was not in the Land Use Commission rules. This was added, I think, more recently with your last update. Prior chair, I think, was not necessarily always interested in hearing, dissertation of the staff report. I think the expectation was the commission had already read the staff report, and that was representing the staff's view on a particular project. But we could certainly provide a high-level overview of here's the site, here's the type of relief that is being requested, here are, the specific related to this case, here's the conditions staff is recommending and why, and we can then kind of also elaborate on the recommendation that staff has on a particular case.
So you're suggesting to change the may to a shall? Is that what you're saying?
Well, I think may is fine, because certain cases are pretty minor, and you don't really need to go into great detail. But I think that for anything where there's, particularly where there's a significant number of conditions being suggested by staff, or it's a major case, I think, any of the planned developments, I think it would be.
So what are you suggesting we change?
I'm not suggesting.
I think she's just requesting that we start doing it. If I understand. Chair.
Yes.
Yeah.
Yes.
Absolutely. We can start working that into our practice.
Sorry, I was confused.
No, that's okay.
All right.
All right, I'm going to scroll down to section 9 and 10 because I want to make sure I understand this. So the next bullet item is clarify the Land Use Commission's purview as it relates to case review. So I think in this case, it's referencing your deliberations and standards for approval. I think providing a little more clarity here that your deliberations need to focus on the standards of review for any particular case. You should be weighing testimony as it relates to those standards by which you have to find met or not met. And how those standards and specific conditions being applied, which is kind of the next one, which we've had come up in recent cases, which talks about clarifying the addition of conditions in order to ensure that any particular standard is met. So at this point, staff would recommend some clarifying language in section 9 and 10 around your purview of reviewing a case, which should be, limited to the variances being requested and the standards by which you need to find met or not met. And then we would also like the rules to clarify the addition of conditions and ensure that anyone on the commission recommending a condition would do so in order to ensure that any standard is now met. This has come up recently in a couple of cases, and I think it would be beneficial just to get some feedback on how you would like to conduct yourselves as it pertains to adding conditions.
Yeah, totally agree.
I agree, although I would note that in some cases, there was, some discussion about if you add a condition that may allow one standard to be met, which is fine, but you may still have other criteria that you don't think are met. So you still would vote against the project.
Yeah, absolutely.
And I think that, one of the reasons to be a little flexible, because, the conditions go to the city council as we've, whether or not we vote in favor of a project or not. So I think that, if adding, a certain condition will allow one standard to be met, that's helpful, even if there still are standards that are not met, which causes the commissioner to vote against it. So I think that there's, it's a little, it can be a little fuzzy.
Yeah, and I think that's how staff is viewing it as well, Chair, is, if a commissioner is going to recommend adding a condition to the project or the application, it should ensure that any specific standard they feel is not currently met is then met with that condition. It is possible that they can't come to adding a condition that would ensure that a certain condition is met and they would still vote no. But when adding a condition, they should specify that this is being added to make sure that that particular standard is met for them.
Right. So when our recommendation gets to city council, the way they should interpret it is the following. So if in the case of, let's say we voted in favor of a proposal 4-3 with a set of conditions, then city council should interpret that as they have a positive recommendation from our body and at least 4 people voted in favor of it, contingent on all the conditions also accompanying the proposal.
That is correct, yes.
Okay.
But you could still add a condition even if you know, for a particular standard, even if you intended to vote no on the project. Is that?
That's correct, because you would be finding one of the standards not met because you can't come up with a condition to make that one be met.
Okay. That's fine. And with respect to conditions, I have a suggestion. I think that the minutes, the way they're organized, the last couple of sets that actually do, set out the discussion on the standard, on how the standards have or haven't been met. I would suggest that, in the motion, it's typically, we move to approve this project with all the conditions listed on page 6 of the packet or whatever it is. I think it would be helpful in the minutes if those conditions were included in the minutes so that when the council gets the record, they have, the summary of the case, the summary of the testimony, and then, the review of the standards. And then also, the motion is, here's the project, here are the conditions, and then the vote, which is not part of our rules, but that's kind of my request for maybe how we can make it clearer for the council, because I think, that's kind of one of the reasons we, recommended a year or so ago that having more discussion in the minutes, rather than here's the vote, here is the issue and here's the vote, so I think that it's, since, we no longer, thankfully, have, transcripts, written transcripts of testimony in the hearing, I think that the complete summary of what the recommendation is would be not only helpful for the council, but the public as well. So you don't have to go back and look at what the original packet was.
Yeah, that makes sense. We can certainly clarify that. One item I think that kind of goes along with this is there is a provision, I believe, in your rules that relates to findings of fact and those being in writing as they relate to the standards of approval. Typically at commission meetings, you are verbally walking through the standards and agreeing to them kind of on the fly. In past practice, some of our planners have brought up that they have actually drafted written findings in advance of deliberations on behalf of the commission in a neutral way, so that, it could be interpreted that any standard is met or not met for a list of reasons. And typically it's based on the staff recommendation, and you always have the discretion to modify those as you're going through your deliberations. But we wanted to clarify, and maybe this is what you're getting at, Chair, would it be beneficial to have more of a written formal findings around how the standards are met or not met and the reasons for them?
I'm fairly ambivalent about the need for that, but I think it's important that we do go through them. I think that it's very helpful to have kind of the staff, written suggestion, even if we disagree. I mean, it's easier to come up with, why I disagree or why the, other commissioners disagree with the findings, and I don't know that it's necessarily for you to come up, to have staff. I'm almost imagining the neutral would be, well, you could, if you agree with this, the standard is met for this reason, but it's not met for this reason, and I think that would be very confusing.
Sure. I would just want to clarify in your rules then that written findings of fact are not required to be provided, because right now I do believe it specifies they have to be in writing, and if we're going to have that rule, we need to follow that rule. So that might be a change that comes in for your review once this comes back.
Right. I think it's important that we go through and we have the findings of fact is important. And I think that it's important that they be reflected, whatever the narrative is, in the minutes. And that's kind of why I think the minutes are so important. And that and generally, I or whoever's going through the standards will refer to what staff has provided. And then if we disagree, we have to come up with with the reason. So.
Right. Okay. Thank you. That's very helpful.
Any disagreement? Would you rather have a form? Okay. Right.
Thank you. So that concludes the list of items staff had identified in the packet, and we just wanted to open it up for open discussion on any other areas of the rules that you, in your review, have identified that you'd like further clarification on.
I had one on cross-examination, section 5. So the rules make several mentions of cross-examination, but it doesn't actually say how it's supposed to work. And we've experienced a few instances in the past year where it turns into some kind of like uncontrollable back and forth between people at the lectern. So I'd like to add some language that clarifies that members of the public have the right to present however you want, I'm just brainstorming, like present a directed question, to the applicant and have the applicant respond, but not in like a law and order free-for-all.
I think that they're supposed, the way we've tried to do it is that the audience will, ask the applicant the question, and I'll play referee and jot them down, and then ask the applicant to respond kind of at the end. But I think you're going to have to check with law, because there is, there was a whole bunch of litigation, like 20 years ago that really, was kind of, came down as kind of a law and order sort of Q&A sort of thing. And, we've usually tried to keep it a little less formal than that, but I checked with law to see what's
Yeah.
appropriate.
I think everybody would benefit from a little more clarity on what cross-examination exactly means and entails, and I certainly would want our legal team to weigh in on that, because I'm definitely not a lawyer.
No, and this actually is a whole big thing on Illinois land use law, so I would.
Yep. So yes, but point taken, I think clarity here is really important, and the last thing we want is kind of the adversarial legal battles back and forth as part of these proceedings. But I think given the quasi-judicial role that the commission does play, it is important that we at least afford that opportunity for cross-examination. It's just, what does it mean? So maybe a definition and then kind of some examples of how that would work would be beneficial.
Okay.
Right,
think
any
that's-
others?
I think, well, the only other thing that, a member of the public raised with me is whether or not if we, we always, make our motions in the affirmative, and if a motion gets voted down, is there any need or requirement to have a second motion saying, well, instead of recommending approval, we recommend denial? I mean, it seems a little overkill to me, but that may be something to, ask law about.
If that latter part's required?
Yeah, if we should be doing something. I mean, it seems to me that if we vote, that we vote not to recommend something, that should be a motion to forward to the council, but.
Yeah. And I think, Robert's rules do generally prioritize that motions be made in the affirmative, and if then the votes fall where there's not enough votes to uphold that affirmative motion, it's considered, a negative recommendation by the commission. But we can certainly ask legal.
Just ask.
Yeah.
I don't have a strong feel one way or the other, but I think that would be useful. Okay.
No, I don't think that we have to vote twice. It will be even more confusing. Maybe the wording at the end of our vote should be something like denied or negative.
Maybe it goes in the, after the vote, and I
So
think
that
it does in the minutes.
Yeah.
As, based on this vote,
But not a second.
a negative recommendation is forwarded to the city council or something, so maybe we could just deal with it in the minutes.
Yeah, no, we can certainly ensure the minutes reflect that. But I do think the ordinances as well that then travel to city council kind of reinforce that negative recommendation based on the no votes in the positive motion.
Yeah. Thank you.
All right. Well, with that, I think, well, I'll let you do the proceedings, Chair. Sorry.
I'm sorry. I'm so used to having public hearings that it's, all right. With that, the next item on our agenda is the draft Housing for All Strategic Plan overview. And again, this is a discussion item, so we're not going to be taking any votes. Am I correct?
That is correct. And I want to recognize we've got Uri Pachter, our senior housing planner, online this evening. He's coming off of the first day of the APA Illinois conference in Chicago. So he's joining us virtually this evening. I'm going to go ahead and share this presentation. And then I'll kick it over to you, Uri. But you're correct, Chair. We do not need any formal recommendation this evening from the commission. So, Uri, it's all you.
Good evening. Want to check before I continue. Is the audio working well? Are folks able to hear me?
Yes, you're fine.
Great. Good evening, Chair Lindwall and members of the commission, Uri Pachter, senior housing planner. I wanted to provide a brief overview about Housing for All draft plan, the City of Evanston Strategic Housing Plan. The draft was released on September 12th and was introduced in detail to the Housing and Community Development Committee in September. And there's about a month-long period for public feedback. And part of that is us coming to this commission and giving, again, a brief overview and an opportunity to share feedback as members of the commission. As you can see in the bottom left, there's an opportunity for anybody on the commission and members of the public to provide individual feedback. And that's going to take place through Sunday, October 12th. We can go to the next slide. So at a high level, Housing for All, which again is synonymous with the city's strategic housing plan, is similar to other topic-focused strategic plans that the city has, like CARP for climate action or Preserve 2040 for historic preservation. City Council has had housing affordability as a major goal for a number of years, and there isn't an equivalent plan that speaks to housing in the same way as other key focus areas of the city. So this initiative is seeking to fill in that gap and move forward with housing action, which I'll speak to briefly on the next slide. So this plan is looking at a 10-year time horizon, and three main areas of the plan are assessing housing needs, establishing priorities based on those, and really with a focus on taking action. The needs are important to act on, or otherwise the plan is just a process in of itself. We can go to the next slide. So some key aspects of the plan focus on a vision of housing options in Evanston that are accessible, attainable, connected, equitable, healthy, integrated, safe, and stable. And before we jump to the next few slides, I want to highlight a couple components that led to the plan. And as you'll notice, the slides are differentiated, and it's an important distinction to call out. A consultant team from Development Planning Partners based in the Chicago area worked on a housing gap analysis that we released simultaneously with the draft plan in September. And this document is entirely consultant-led and focused on the needs piece of this planning process. And so that element is a key foundation to the process that we're discussing now, the plan. And so the gap analysis itself is final. It's a document that we're leaning on and looking to for a bunch of data and takeaways. And the plan itself is in a draft phase and will iterate through the Housing and Community Development Committee, through public feedback, et cetera, and then go on to City Council. So I wanted to highlight, we can go to the next slide, a few of the elements of the report that the consultant team put together. So the main focus of the report is on identifying gaps in the housing market in Evanston, with a particular focus on households that are cost burdened, meaning those who are spending more than 30% of their income on housing costs. And these changes to housing cost burden can happen for a variety of reasons. Many of them are outside the city's control, but it's important to identify what are those that are in the city's control that we can take meaningful action on. One important thing to note is that this gap analysis identifies gaps in housing cost burden, and therefore sort of the need, but it's not a quota about the number of units that are needed to be built. It's more about what's the magnitude overall, and in some other specific subpopulations or housing types. We can go to the next slide. And so at a high level, a little bit more than a third of Evanston households are cost burdened, which is over 11,000 households. It's a very significant number, 11,000 households. And a significant portion of those are renters. Almost 50% of renters are cost burdened, and still a pretty meaningful amount of homeowners are cost burdened as well, almost 1 in 4. The analysis predicts, based on their model, that the gap will decrease over time over the next 10 years. However, it's unclear why that would happen. It may be for positive reasons, like households gaining income, and it may be for negative reasons, like households with lower incomes being displaced, and therefore they're no longer counted as part of the community. And as noted, the largest rental gaps are particularly among households that make less than 80% of the area median income in the larger Cook County area. We can go to the next slide. these couple slides basically point to another way that the analysis was being done by both housing type and by geography. So on the left, we're looking at renter households, and on the right, looking at homeowners and where there are more significant percentages of cost burden in each census tract. There are 19 of them in Evanston, and the darker colors are the areas that are seeing more cost burden, whether it's among renter households or homeowner households. We can go to the next slide. So there are a variety of takeaways that and areas that the development planning partners dug into, but a couple that we wanted to highlight tonight are impacts in terms of race and ethnicity. There's a significant income disparity, and therefore that impacts housing affordability in a meaningful way among different racial and ethnic groups. And it's particularly notable amongst the Black Evanstonians. And as you can see from the couple bullets at the end, the differences among Black households and white households is very significant in terms of what is affordable in terms of 1 bedroom, 2 bedroom, and other types of units in the community. We go to the next slide. Another component as an example of their analysis is more on housing type versus population. And in comparing Evanston to Cook County and the city of Chicago, you can see that Evanston's missing middle housing, which according to this analysis is defined as attached single family homes or multifamily housing that's up to 4 units. So including duplexes, triplexes, et cetera, that in order to match the county share, which they're deeming a relevant comparable versus the city of Chicago, which has a different series of circumstances where that's not really an appropriate comparable, the city would need to add an additional a little over 2,000 units to match that share. And that's important because a variety of households would benefit, including younger families and seniors who are looking to downsize. So we can go to the next slide. And there's a number of takeaways, as I mentioned, from this analysis, and some of them that I just wanted to reiterate because they're key components of the current draft plan and the strategies that come afterwards are economic and racial diversity are at risk. We've seen the Black population has declined in the last period of time that the report and other data speak to. While Evanston's diverse overall, it is meaningfully segregated, and that speaks to opportunity and limited choice. Households should be able to live in areas that they're currently living, but also be able to seek out other opportunities as well. While renters are definitely the most cost burdened, there are lots of challenges for households to become homeowners. And there's diversity in the needs of older adults and students that is more complicated than just students needing a certain type of housing or all student households looking like a certain type. And similarly for older adults with a variety of incomes, the needs are very different. So I'm going to go over some key elements of the plan and then really try to keep it brief so that we can lean into the discussion portion. So a few key areas are going to be goals, objectives, and strategies. And so on the goal side, a really meaningful focus is around reducing that cost burden. That is a really key metric. And other supporting components, excuse me, are measuring and looking at how many units we're preserving and creating. The draft goal is between 3,000 and 5,000. And the reason that these goals are listed as ranges is because over the course of 10 years, there can be drastically different funding scenarios. We want to acknowledge differences between low funding, low impact scenarios and high funding, high impact scenarios. The next 3 around economic diversity, racial diversity, and segregation are a little bit harder to show what the base is in a quick chart. And so those asterisks aren't, we don't know, but they're more for an easy chart. We're not going to go into all the details. The key is we want to make sure that household income distribution and racial distribution are maintained, are maintained, that we're not experiencing significant displacement, and that segregation decreases as well around the city. We're also looking at some secondary metrics, which are on the next slide. And those metrics include permanently preserving affordable units, reducing the homeless count, and then looking at other ways of measuring actions as well in terms of dollars spent and leveraged and housing partnerships. And you can see the goals affiliated with those on the right. And these, it's all about over time, and so there is no base. It's about what we're doing over that period of time in this section mainly. So the three main objectives of the plan are shorthand: preserve, create, and protect. And in not that much longer, but in a little bit more detail, focused on preserving affordable housing units. That's not with a capital A. It's any type of housing units that are affordable, meaning households are spending less than 30% of their income to a meaningful portion of the community. Again, particularly those with lower incomes who are experiencing significant housing cost burden. The second one is creating units, and those units are in a variety of areas that would address gaps in the supply. So they could be like missing middle housing that was discussed previously. It could be other types of market rate housing or affordable housing, maybe focused on seniors or folks with special needs. And then protecting residents from displacement. While the first two are much more focused on the units themselves, the third one is very directly focused on individuals or households to assist in preventing displacement. I want to just flag that in the top right-hand corner, you can see the little icon that says provide your feedback. And that's just an indication that from here on out on all of these slides, the feedback form that's been circulating in the community for the past 3+ weeks includes an opportunity to provide feedback on all of these components. And we're getting significant feedback from the community about these elements, which is exciting. And there's still, again, 4 more days through Sunday to participate in that. There will be additional feedback opportunities after that as well, but this portion will close then. So as part of the plan's proposals around these 3 objectives, there are a series of strategies that slot under each of these objectives. I'm not going to go over each of them in any detail, so we'll just pass through them quickly. But preserve, there's a couple of slides. I believe there's 9 or 10 strategies that fall under the preserve category. Units that already exist and making sure that they exist for significantly much longer time or in perpetuity. And then there's a series of strategies that are focused on housing creation. These units either don't exist, the buildings themselves might exist in its adaptive reuse, but there's new housing units coming on the market and available to Evanston households. And then again, the last one, while all of these are focused on humans, people, Evanstonians, households, the last category is much more directly so, since they're less focused on units, and it's about protecting residents from anti-displacement. So a couple of things I wanted to highlight before I wrap up. As I mentioned, this plan is a draft plan. That's why we're excited to be here to get additional feedback from this commission. There are lots of strategies included. That is intentional. It may be too many for the city to be able to take on during this time period. We wanted to get feedback from the community about a lot of ideas so that we can continue to focus and identify those that are most impactful, will move the needle, and that are aligned with community feedback as well. And there are other areas that we also understand are lacking in some detail, and that is intentional. As we move forward iteratively with this planning process, we will add more detail in to support the strategies as we continue to focus. Any suggestions on that front are greatly appreciated. The bottom line that we've been able to identify here at a high level is there's a lot of housing challenges and it requires bold action. We're not going to be able to do it alone. We're going to have to work together. We're going to have to be creative about finding funding. And really the economic and racial diversity in Evanston is at stake. It's not a planning exercise. It's people's lives in Evanston and seeing if we can really continue helping Evanston be the wonderful place that attracts so many people to live in this community. Ending on the feedback note, there's been a variety of things that the city has done to encourage participation in providing feedback. Here are a number of those ways, and I don't mind being a broken record. The feedback form is available online. The QR code's there. The website is listed below. This is on the next slide. At least on my end. Oh, there we go. Okay, great. You can scan the QR code, go to the website. The website will be available, for the course of this whole planning process. There are paper forms available at 6 different locations. You can pick them up there and drop them off there. All the input will be included in an equal manner, regardless if it's English, Spanish, paper, or online. And I look forward to hearing a healthy discussion around how we can continue to improve this plan as we move forward in the process, in the legislative process. Thank you very much.
Okay, thank you. Do you have suggestions on how to approach this? First of all, I want to make sure that one of the things I'd like to encourage all of us to do is to go and fill out the survey, because I'm not sure that it's, well, I want to encourage discussion around some of these points. We're not taking a vote on whether or not we agree with any of these particular strategies for achieving the objectives. So, but I'm going to start because I've got a couple of kind of general questions about the beginning, the introduction to the document. One of the things I noticed on your the renter versus the rental cost burden slide is it appears, there's a census tract in Northwest Evanston that seems to really be the Presbyterian home. So I'm not sure, the real dark area over in the yeah, that one, which, again, there are certain, the gap analysis highlighted that there are certain areas that are heavily populated with students who may be, technically cost burdened, but may or may not be really, cost burdened depending on what their financial situation is. I know, I live in that neighborhood, and you have certainly students that are, banding together and each paying their $1,000 and living 6 to a house, which really, their capacity, well, no, there are 6 next door to me, actually. But, so they can spend a lot more than a normal family household probably could. And I don't know, I know the census has, or the American Community Survey has, tries to get the people living at a certain address as a household, but I don't know that students always fill out the form properly. So I think I just wanted to point out that is just kind of an anomaly in your data. But I think that the gap analysis that was done very well, and it's great to have all of this data. But I do have a couple of questions. First, when and when the description of the 2022 E-Plan is talking about the loss of duplexes and townhouses and things like that. Is that really happening? Do we have evidence that we're actually losing those units? I know that there are fewer than there are other categories, but do we know?
Sure. Thanks for your question. Off the top of my head, I'm not sure what the change is over time in those types of units. That either reflecting the E-plan or outside of that, but we have data on that, and that's something that we can
I just
go back to
I-
and
yeah,
double check.
again, it's just a matter, if you make the statement saying we're losing townhouses and duplexes, we ought to be able to document that that is in fact happening. And, I certainly know that, lead paint is an issue. I know that, code enforcement is something that we want to encourage, although, again, we have to be sensitive to encouraging code enforcement, because if you look at the, kind of the history of Evanston and the segregation, the redlining and all of that, that's how black households were moved out of certain neighborhoods in the past. And, but it's important in terms of maintaining the housing stock, it seems to me. So that's one question I had. And then in looking at kind of the household income by race, the kind of the distributions, one thing that struck me is the high percentage of Asian households that earn less than $25,000 a year. And again, it's, I just wanted to see, it would make sense that we're dealing with student households, but I don't know that that's the case. So, I think that the point is that there is clearly a student impact, which you've recognized and acknowledged. I don't think any of us know exactly which census tracts are impacted or not, but that's a factor. And then I think the other thing that I noticed is that one of the major gaps were housing for middle-income seniors that's suitable, not necessarily our, the large single-family housing, houses that they may be in right now. And I would contend that the notion of building double houses or duplexes or townhouses, which are most likely going to be, units with stairs, are not what, middle-income senior households are going to be looking for. I think, you're looking at smaller multifamily buildings with elevators. That's just kind of a reaction to sort of looking at the building types that are being proposed as part of the, the future zoning regulations. So I think that trying to match what the real needs are with the housing type, it's not necessarily, there are two kinds of missing middle. There's the missing middle in terms of the unit types that have been documented, but there's also missing middle in terms of income. So that's just kind of my takeaways from just kind of general. Any other comments?
Yeah, I have a question. Hey, Yuri, Max Puchtel. Nice job on the presentation. Thank you. I wanted to know, I heard you say that the analysis concluded that, there's a handful, several thousand units of missing middle housing that would make sense for Evanston to prioritize building over the next time period. Did your analysis identify where those units are currently lacking, like geographically or by ward or anything like that? So I hear that there's a deficit and we should prioritize building more. Are there certain areas that already have sufficient amount and other areas that are deficient, places that we should focus on?
Yeah, good question. So the analysis that the consultant team did didn't identify that, and that wasn't part of the scope that was asked of them. And I think what's an interesting process for the city to do is really identify what is appropriate, because I don't think there's really there's not really a metric where it's like, oh, this census tract has a lot, so they have enough and they need to go other places. Maybe the census tract that has a lot actually needs to have more. It fits in better with the community there. And so a lot of that will end up being something that we can do more data analysis, and we can look at where those locations are as well, and that can inform some components of future zoning reform. But I think a lot of it will end up being a decision that the council ends up needing to make ultimately about where the preferences are.
Because in the past, this group has heard when we're, for example, when we're looking at a case about whether or not to approve a new construction of an affordable housing complex or having a portion of affordable housing, we've heard testimony from members of the public in those areas that have argued, you know, we already have a lot of quote unquote affordable housing in our particular area. You know, why is it only being why are these projects only being concentrated in our neighborhood? And without commenting on whether or not that's right or wrong, or whether it should be concentrated or not, what's important to me when we do the next zoning code overhaul, which I presume that this housing plan is going to influence, it's important to me that there aren't any areas of Evanston that are off limits from, you know, these kinds of goals.
Yeah, I'd like to kind of amplify a little bit on that. I think what was interesting in the presentation that the consultants did was they made very, very clear that this 3,000 to 5,000 units were not necessarily new units. It also included preservation of the naturally occurring affordable units that are in Evanston, in addition to the ones that are subsidized. Am I correct in that? You know, so we're not talking necessarily about building. They made very clear and repeated several times that they're not talking about building 5,000 new units necessarily.
I do want to clarify slightly.
Okay.
They were not talking about a build quota. However, the 3,000 to 5,000 is the current city recommendation for the next 10 years of a combination of preserving or creating. That's city-led. Their analysis finds over 11,000 households that are cost burdened. So the problem is actually much more severe.
Right. Although Whoop, I
Sort
lost
of
you.
a combination of achievable numbers. And so just wanted to make that distinction in terms of the number portion of it as we move forward. Yeah.
Right. Anyone else have thoughts?
I want to mention several things that I noticed, and once again, my comments are a little bit more general, I would say. I tried to read everything in the Housing for All and in the GAP report. I think I read it. I think I understood most of it, and I would say these are very good documents. And they're really necessary to be at our disposal and at the disposal of anybody that plans the future of Evanston. My, let's say, question or wish is the following. First, we have a kind of a different timeline of several very important documents. And for me, being urban planner and architect, the most important thing is the comprehensive plan. So we have a comprehensive plan that is currently still it's still evolving, it's still under considerations, but it is based on certain things. And once again, I'll mention data, because we have to have for any planning solid data. But besides the comprehensive plan, we have these old documents. I put them on a small list. We have a housing plan with a goal in 2035. We have the Envision Evanston 2045. We have the Preserve that is with goal 2040, and then we have an E-plan that is 2022, the year of doing it. My point is, all these plans are very important documents, very important documents. But in my, let's say, knowledge and practice, there are certain processes that go in planning, especially in urban planning and comprehensive planning. It is, you have to gather all the analytic data. You have to make a synthesis, and after that you have to make decisions. What I noticed is that all these plans, and I went through some of them, they somehow use not matching data. And I will show you certain things. For instance, GAP uses mainly the 2020 census. In Housing for All, you can see also the census, but you can see also the survey. And these numbers differ. And then everything starts a kind of with certain deviation from one to another. The number of population, the number of dwelling units, the number of households, their progression throughout the years, and I don't speak about till 2045. But all this makes the decision makers kind of hesitate what is really happening here. The tendencies and whatever is on the Housing for All, I would say these main goals and these main strategies are correct, and they have to be protected and they have to be done. But how much, how many dwelling units, population, households, are we sure in our numbers? For me, this is really important. And besides the timeline, because I mentioned about all these plans, I would like to have them before the comprehensive plan, so that the comprehensive plan uses the very important conclusions of all these plans, summarize them in a single document, and then this is the document that actually makes the policy of the city of Evanston for the 20 years ahead. So this is, once again, I'm mentioning it's more of a wish, but maybe when we continue with this, we can kind of synchronize all these plans, align the data between them, and even make it, because one of these plans, I don't remember which one, is 5-year plan, or its goals are in 5 years. Maybe 5 years is a good period of time to control how this plan is executed, how it is progressing. Maybe that. But my point is, isn't it better if all these plans are made maybe at one and the same time, or even if there is certain difference in the years of making, they are consolidated in the comprehensive plan. And this will be much, much easier for everyone to continue working with this document. So, once again, this is more than wish, more like a wish than currently. But if we can, with time, try to make these things, I believe it will be better for the city of Evanston.
Yeah, I'm going to respond, Ori, if you don't mind. I couldn't agree with you more. I think one of the goals of all of our planning should be to have some sort of centralized database by which we're tracking data to inform decision-making. Our team had intended for 2025 to be the year of data, where we wanted to build this robust, I have a very similar goal and dream, Commissioner Miranchev.
Very happy to hear that.
Yeah, and unfortunately, we were thrown in the ringer with Envision Evanston and had to lead that when our consultants were off-boarded. So that project has somewhat been pushed to the side, but I can tell you that community development is very passionate about wanting to build out our knowledge in terms of data-driven information that we're presenting to decision makers moving forward. And I think it's something that, we can be more intentional about in terms of potential strategies or actions that the city can take related to our various planning initiatives to ensure that we're looking at things consistently. There are different requirements for different plans that we do conduct here, which is always going to be the case. We're never going to be able to sync them up and have everything on the same year because, honestly, I don't think there's enough staff power or consultant power to make that a reality, and probably would be a lot to handle. But we can definitely do a better job at building out data, and that was one of the things that DPP did for our team as part of this initiative is they built us a model by which we can plug in refreshed data as it becomes available so that we're constantly tracking these various metrics that are identified in the plan. So we're working towards that dream that you kind of laid out for us.
I still have a dream.
No, you're allowed.
But
always dream,
by the
please.
way, I really appreciate your input because once again, I can see how the department works. I'm sorry about the not very good consultants that we had along the way because it was mainly their role, but I can see your effort and I sympathize that completely.
Appreciate that.
Yeah, I think I will echo that as well. It's great to see the data that's in this document. I think it's especially by census tract, because you can kind of look at it and say, yeah, I understand kind of why this area is the way it is, and how things evolved. And I think that it was really helpful to have some of the background documents. I particularly enjoyed the kind of the history of redlining and segregation in Evanston that Dina Robinson and Jenny Thompson put together. That was filled in gaps way before my time in Evanston. So I thought that was helpful. Anyone else have any comments, thoughts to share? I have actually one other, the appendix, the history of Evanston, of housing in Evanston. I actually was around, there are a couple of things that the 1950s to 1960s, to my knowledge, we did not have any public housing in Evanston at that particular point in time. In the 70s and 80s, where that was when I started at the city, and that's a time period I know about. That's when public housing did come to Evanston. There were, the Noyes Court project was built in the kind of late 70s, early 80s, somewhere in there. And also, Evanston was one of two Cook County communities that allowed the Cook County Housing Authority to build scattered site family housing. Wheeling was the other. So I think that probably ought to be reflected. I know that it's just an appendix, but I think you ought to revisit the description of the 50s and 60s. From my reading, that was still a very segregated period of time in Evanston, and, I was a Northwestern student starting in 1967, and I can attest that the university wasn't particularly forward-thinking. I mean, my freshman class it was the first where they had any sizable number of black students, and they were big on geographic diversity. I came from California, and we had students from Hawaii and Colorado and all sorts of far-flung places that I think they were sorry that they, admitted us after the fact, but they did. And the other piece in the 80s is that's when a lot of the older rental multifamily buildings transitioned to condos. There was a huge condo conversion wave, so which, the Plan Commission at the time, that was one of the concerns. I staffed the Plan Commission for a while, and, I don't know why it always gets buried, but there was a 1985 comprehensive plan that, when they were looking at housing, that was kind of one of the big concerns, was the loss of rental housing, due to condo conversions. So, I think that there's probably a little more. I know Megan or some, you have the 85 plan is somewhere in the city, so that might offer a little bit of kind of some of the issues that were happening. I think that the format and stuff is good. I have some comments about the strategies, but I can leave those, I can add those to the online. And, so.
Yeah, I think the overall document is really strong, and I appreciate what's happening and where we're looking for our city. But I think just one note I have is, like, it is a lot to be done, and how do we not just stay in the planning phase, the research phase? How do we actually get through to completing some of these very necessary and needed tasks that are laid out here? And so, just as clear as we can be, and who would oversee these, who needs to be responsible for these projects and these tasks, and then, what are the accountability measures? What happens if they're not met? What happens if we're, slowing progress towards getting those? Just as clear as we can be in that, I think will be beneficial.
I think the other thing that struck me in listening to the the presentation from the consultant team and stuff is this notion of friction. So that even if you have a policy that says you're going to build, you're going to encourage accessory dwelling units, there are reasons why people are not building them. I mean, my kids think it would be dynamite if I, replaced my garage and, and added an ADU. But quite frankly, I don't want to be a landlord. Besides, the other, the financial and other things that many other people have, it's all they can do to be, to afford their house. So I think that the notion that not all of the strategies are going to, there's not a single strategy that's going to, turn the tide and make the difference. It's not like you can, even if you were to, I know upzoning is, it's kind of, the community is divided on that as a concept. But I mean, I think it would be really interesting to know how many single-family houses there are in R4 zoning districts, for example, because they've been zoned that way for decades. And there's still lots of single-family houses in them. And, just changing a zoning district isn't necessarily going to encourage somebody to build. I mean, the fear is that what's going to happen is that where the naturally occurring affordable housing is now, especially the owner-occupied units, is they're going to be bought up and replaced by high-end units, which I suppose makes those areas more economically diverse, but I'm not sure that is where the community wants to, I'm not sure that really achieves the objectives of the plan. Anyone else? Liz, you have anything else?
No, I just appreciate the feedback as we move through this process. As the chair mentioned, feel free to fill out the feedback form online. We can take the feedback that we heard here tonight and, incorporate that into, the recommendations that move forward to HCDC on October 21st. They'll have their first opportunity to provide kind of substantial feedback at that time. And then from there, we're really going to lean on them to guide next steps in terms of when we'll bring back a revised draft incorporating both the public's feedback, commission feedback, and things that staff believe should be enhancements to the current draft. So thank you for the discussion this evening. It's exactly what we were hoping for.
Okay, thank you. With that.
Thank you very much.
Thank you. Hope the conference is going well. Okay, with that, our next agenda item is public comment. Does anyone want to address the commission? All right, in that case, may I have a motion to adjourn?
I'll move to adjourn.
I second.
All right, all in favor?
Aye.
Aye. All right. And just, the next meeting is November 12th, right? We are not meeting on October 22nd. All right, thank you.